This Honorable Court of Appeals is now in session.
Thank you, Ms. Lindsay. And on behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which we are live streaming for the public's access so that we can keep the courts open as we are required to do. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes, and the appellant has the right to reserve some of that for rebuttal, and I understand that's been done. Unless there are any announcements, I'll ask Ms. Lindsay to call the case.
Allison Haynes versus Perry County, Tennessee.
All right, Ms. Thorne, you have the floor.
May it please the court, my name is Leanne Thorne of the Henderson County Bar, and I represent Ms. Allison Haynes in this appeal of the dismissal of her case against Perry County, Tennessee. A little bit of background factually about this case. My client, Ms. Haynes, at all pertinent times was married to Mr. Earl Gene Haynes, who had a significant and serious violent history of domestic abuse, having killed his first wife, been convicted of that offense, and having served a sentence for that offense in the Tennessee Department of Corrections. Upon leaving his confinement in TDOC, he married my client, Miss Allison Haynes, and the domestic abuse continued throughout that second relationship. The matter came to a head in the summer of 2018 when several incidents arose that were documented both in the Perry County Sheriff's Department records as well as the Perry County General Sessions Court records. First, Miss Haynes' car, which was located at the marital residence in Perry County, was vandalized by burning. This was investigated, and Mr. Haynes was a suspect in that ongoing investigation. That led Ms. Haynes to obtain an order of protection through the Perry County General Sessions Court. She sought that and obtained that. When that order of protection was served by an officer of Perry County, Mr. Haynes explicitly stated that he should just go ahead and shoot Ms. Haynes between the eyes and get it over with because he was going to be violated anyway. Despite the ongoing abuse that Ms. Haynes suffered, she did voluntarily go back to the Perry County General Sessions Court and voluntarily withdraw her order of protection. Unfortunately, as someone who practices in General Sessions Court and sees victims of domestic abuse very frequently, this is a very common practice. It doesn't mean everything's okay.
Was that fact alleged in your complaint that the protective order was subsequently dismissed?
It was.
Okay.
It was voluntarily dismissed, but nevertheless, those pleadings were still on file in Perry County General Sessions Court. And Ms. Haynes mustered the courage to leave again. She decided to move in with her friend Cindy Keene, who is a resident of Wayne County, Clifton, Tennessee. Ms. Keene was kind enough to allow her to stay there and hopefully be safe from Mr. Haynes' domestic abuse, but it didn't take long for Mr. Haynes to find Ms. Haynes and to begin levying death threats against both Ms. Keene and Ms. Haynes. Ms. Keene did the correct thing. She called the Perry County Sheriff's Department. She relayed the very specific, direct, serious threats that were being made against her and Ms. Haynes to Perry County. She was unable to reach anybody on the phone, so she left a detailed voice message. That message was never returned. She continued to get these threats. She and Ms. Haynes both, she continued to report them. Multiple times she reported them, and that is in the complaint.
So does the complaint allege that your client, though, actually made a call into the police or sheriff's office?
No, and that is not the case as far as my investigation. And frankly, that kind of lines up when someone is afraid of their abuser. This happens many times that third parties make these reports, and I don't think that abrogates Perry County's responsibility in investigating a crime. So under your theory, then I guess any time someone calls the police or sheriff's department and reports threats, that would create a special duty then? Well, I would say that it doesn't fall under the special duty exception as such, except to the extent that it can be reckless behavior, because as this court noted in the Carnes case, reckless conduct can establish a special relationship when that public employee is aware of and consciously disregards a substantial and unjustifiable risk that would be a gross deviation of the standard of care. So our legislature has set up a framework for domestic abuse situations, which was outlined in my brief, in that when domestic abuse is investigated, it's actually somewhat presumed that there should be an arrest made. It doesn't even.
Is there anything in the record that explains why no investigation came out of these phone calls?
No, there was no real reason. And in fact, the domestic abuse statutes state that if no arrest should be made, there should be a record of why that did not happen. The only time that there was action taken in this matter was when Ms. Haynes was shot multiple times with a 9mm. So back to kind of where we were posturally with the case, we obviously filed this under the Tennessee Governmental Tort Liability Act. We also alleged Tennessee Code Annotated Section 88302 as an alternative ground. The defense filed a motion to dismiss, saying that Investigator Rawson's actions were discretionary, or in the alternative, that the public duty doctrine protected Perry County from any type of lawsuit.
So was Inspector Rawson was the person to whom these calls were assigned?
Yes, he was the investigator, and he was the one for whom the voice messages were left. And so the court accredited both of the arguments of the defense, saying first that Investigator Rawson was acting under a discretionary function, and secondly, that Perry County was protected by the public duty doctrine. As to the discretionary function argument, of course, the Bowers test is the planning and operational test. We look to see who's making these decisions. Is it an executive official, a legislative official? It was not. Was it a planning decision or a policy-making decision? It was not. It was an ad hoc decision to not investigate, although there were statutes in place that required investigation. Our legislature sets up laws, criminal laws, tells us what the elements of those crimes are. And as I pointed out in my brief, explicitly states that deputy sheriffs are to ferret out crime and arrest criminals. It's explicitly stated, although theoretically that's common sense. That didn't happen here. So this was not a discretionary function. This was an operational function. It was an ad hoc decision. It was not a planning or policy-making decision. The court went on to say that the public duty doctrine protected Perry County and spent about one paragraph, 70% or so of the page, addressing that entire argument. Of that one paragraph, all but one sentence addressed parts of the special duty exception that we were not even alleging. We're not alleging that Investigator Rawson undertook any duty. He didn't do anything. So we certainly don't fit under exception 1. Exception 2 is that a statute creates a cause of action for the plaintiff. That's not the case here either. So we're going under exclusively subsection 3, which is in pertinent part that this was reckless. And again, back to the Carnes case, that special relationship can be created by a public official disregarding a significant, substantial risk of unjustifiable harm. I can think of nothing more serious, more significant, more substantial than someone being threatened with death and law enforcement doing absolutely nothing to investigate that, to even see if it's credible, despite these domestic abuse statutes that exist, that implore and that require law enforcement to act. So we are simply going under that recklessness standard as it pertains to the special duty exception here. And we do contend that what Investigator Rawson did was reckless because he knew, due to the multiple messages left for him, that there was a substantial risk to the life of both Ms. Keene and Ms. Haynes. The fact that Ms. Haynes did not make this report is of no consequence, and it really has no bearing on the special duty exception. It just says that the public official has a knowledge of a risk with a private individual, not necessarily the individual that makes the report. So we would contend that it was not a discretionary function, and furthermore that Investigator Rawson acted in a reckless manner by failing to do anything at all to investigate. I will also just point out, and I know that the defense cited several cases and likened this to negligence, but we tried to delineate the cases that were cited from this case. And I will just say that if Investigator Rawson had made some attempt and he'd gone out and he'd talked to everybody, he'd investigated, he looked at Miss Keene's phone, listened to voicemails that maybe had been left on her phone, and then he made a decision not to arrest, and he had a good reason for that, that would be negligence. But when you don't do anything, when you know that these risks are there, you're repeatedly told, and you do absolutely nothing to abrogate that, then I believe that there is a distinction between what happened here and mere negligence. And I've got a minute or so left. I've kind of gone through if the court has any questions or wants me to elaborate, but I do believe that the court erred in finding that both this was a discretionary function and also that this did not at least meet the pleading standard for recklessness under the special duty exception.
All right, thank you. You'll have time for rebuttal. We'll hear from the appellee.
Ready?
Yes.
Checking that clock up there has 12 minutes. Is that correct?
Oh, it's just the clerk's way of trying to.
Okay. Okay. I was just making sure it was right.
Yeah.
I'm ready to go.
Okay, you're good to go.
Haynes Russell on behalf of Perry County. Here, plaintiff has alleged generally that Perry County is liable for its officers' failure to investigate or arrest appellant's husband for the act that's alleged in her complaint took place. However, the trial court correctly dismissed this case under both the public duty doctrine and the discretionary function exception. Starting with the public duty doctrine, under Ezell v. Cockrell, the government entity is safeguarded from suits for injuries that are caused by the public employee's breach of a duty owed to the public at large. Meaning that if the duty is owed to the general public, it's not owed to anyone for the purposes of a civil lawsuit. And this applies even where an individual's suffered some special injury that was only suffered by them and not the public at large. As an initial matter, clearly the public duty doctrine generally applies here because a duty to investigate or a duty to protect, as alleged in plaintiff's complaint, is a duty owed to the general public, not just appellant.
Well, once an alleged crime is reported, is there no duty to check it out, to investigate it?
Well, Judge, I think that would be owed to the general public. Whether or not.
Once someone calls in, says my name is X, and I'm being threatened by Y, that's not public anymore. That you're down to specific people now. Don't you have duties to investigate once you know specific names and potential crimes?
I think Wells v. Hamlin County is instructive on this issue, Judge. It involved a child was abducted by his father after he had abused the mother. And from there, an officer actually contacted them and said, "Hey, I'm going to help you. I'm going to get your child back." And in the interim, the child was killed, I believe. And still, the public duty doctrine applied to there, even though.
What about Ramsey versus Scott County? Are you familiar with that case?
Not off the top of my head, Judge.
Well, it was a case where a lady's daughter was threatening suicide, and she called the 911 number, and the operator said, we don't investigate domestic matters. And she called the police department, and the police department said the same thing. And turns out the police department's policy was if somebody requested an officer, the officer should go out. And so they found that was grossly negligent, and that the police should have come out there. So isn't that similar to what's happened here?
Well, I think that in Ramsey, that would go to the special duty exception, whether or not there was some intentional, malicious, or reckless misconduct, not.
Well,
generally
yes, it was the special duty exception, and it was found to be reckless. Here, the police were called several times, and they did nothing. Isn't that reckless?
It's not.
The same thing has happened in the Ramsey case. Nobody came. The lady committed suicide.
I think Heard v. Woolfork is another instructive case where multiple neighbors of a man that was formerly convicted of aggravated rape called and said, hey, he's threatening us. He's doing a lot of threatening behavior. Y'all need to come over here and arrest him. Well, in the interim, an arrest warrant was issued, but never processed. 10 days later, it still was not served upon the individual that had been previously convicted of aggravated rape. And the court determined there the public duty doctrine applied, and it wasn't reckless.
Well, yeah, that sounds more negligent than reckless, but there was at least an investigation done in that case, was there not?
Well, he had violated his probation through, I believe.
Well, somebody had to figure that out. Okay.
Well, I believe in this case, any alleged failure to investigate would be discretionary. As you pointed out earlier, or maybe Judge Clement, that there's no general duty to investigate. It's a discretionary decision as to whether or not, one, if I find this alleged threat to be credible, two, whether or not I have probable cause to arrest based on what they've told me, whether or not, and I think it's pertinent to this issue that she had dismissed her order of protection. And I would actually point out that the officer Courtner, who she alleged, he told her he was going to shoot her in the head, that was served in Wayne County. And that's in the record on page 20, that Mr. Haynes was in Wayne County when he was served.
But a simple search of the records of Perry County would have showed this gentleman had been convicted of a violent domestic offense and served time for it, right? That would have certainly given credibility to her calls and made one, an outside observer like me, think one should investigate.
Well, I think that goes back to Investigator Rawson's discretion in allocating his time to other investigations, whether or not that be this one or not. I don't think a cursory.
Do we know do we know he did that?
I mean, it's outside the pleadings, but I know he contacted.
Well, then it's not part of this.
Right.
If it's outside the pleadings, it's not part of this, if it's not in the record. But
I understand.
Discretionary functions generally go to things like planning and not sort of ad hoc operational kinds of decisions. Isn't this more an operational thing than a discretionary decision?
Well, moving to the discretionary function exception, it would be a planning decision because the factors there include whether or not we've allocated any county resources, or the planning whether or not to.
Well, that's not a decision for an officer, is it? That's for his superiors.
Well, as an investigator, he would have discretion whether or not to investigate certain allegations and
what does the record say about that?
Well, it's on a motion to dismiss, Your Honor, so it's on the
right. So we're just kind of speculating here, aren't we?
I mean, these do seem like unusual defenses to be successful on a Rule 12 motion, because just on the face of us, this does seem somewhat reckless that there was no follow-up or no apparent follow-up on multiple calls that someone with a prior criminal background of doing just this thing is trying to kill me.
In two other cases that were decided on a motion to dismiss stage were both Heard v. Woolfork and Kimball versus Dyer County. So on a public duty doctrine. So I don't think it's necessarily unusual based on the complaint for public duty doctrine to be a defense. Now, under the recklessness is defined by courts is when a person is aware but consciously disregards a substantial and unjustifiable risk of such a nature that the disregard constitutes a gross deviation from the standard of care. And this court, and I've already briefly touched on Heard v. Woolfork, but there are other cases that plaintiff is essentially saying that a failure to act is recklessness. Once again, in Heard v. Woolfork, that's a failure to timely serve an arrest warrant. This is, as I explained earlier, a violation of probation, and he was previously charged with aggravated rape. Much like here, there's previous track record of violent behavior, and 10 days went by and nobody arrested this guy despite multiple reported threats by neighbors. And on appeal, this court determined in analyzing a motion to dismiss that was granted that the sheriff's duty to keep the peace and execute the arrest warrant was first a public duty owed to the public at large, and also determined that the alleged conduct was not reckless, holding that the failure to act by timely processing the arrest warrant was not reckless despite the multiple calls in the interim alleging that he was continuing his threatening behavior. And Appellant has attempted to distinguish this in her reply brief by saying that there was only one fact alleging recklessness in that plaintiff's complaint, but in the opinion, you can see it has both paragraphs 6 and 7 in the fact and background section of Heard v. Woolfork, where they alleged a failure to promptly serve the arrest warrant despite knowing of the individual's violent propensity, similar to what has been alleged here. This is also despite receiving multiple complaints of threatening conduct. They also alleged that Sheriff Woolfork had devoted all of his time to the political aspects of his job and had just completely disregarded serving any arrest warrants. And still, the court did not determine this was reckless. I mean, it's a high standard of care to get there where there's some gross deviation, not just maybe some.
Well, the court shouldn't be making a reckless determination, should they? They should just be seeing if there is sufficient allegations in this complaint that they could possibly stand up for proof about recklessness in this case, right?
Right. I mean, the court has to accept the factual allegations and the complaint is true. But of course, any legal conclusions such as this is reckless or this is negligent, the court is not constrained by. Another example of alleged reckless conduct was in Gardner versus Ventura property, where there was a failure to detain a drunk driver. There, he pulled over the drunk driver, had him do a sobriety test. And while he was doing that, he just left. He didn't take his keys. He didn't put him in the back of the patrol car. And next thing you know, he's hit the plaintiff on the side of the road and we have a lawsuit. And the Court of Appeals affirmed dismissal there again under the public duty doctrine and determined that the plaintiff did not show recklessness where an officer failed to confiscate the driver's keys or failed to place him in a patrol car despite him clearly being drunk. Another case where a failure to act was not found to be recklessness is Kimber v. Baker. That was a failure to notify over the unsafe condition of a building, which had a do not occupy. They wanted them to put a do not occupy sign out there to keep people from going in, which despite knowing that the building was falling down, nobody did. And here, similarly, they're only alleging a failure to act. And this is similar to Hurd. This is similar to Gardner, and it's similar to Kimber as well. This is not a gross deviation on its face. Certainly, investigators not go into the discretionary function exception, but they're entitled to some discretion in whether or not they determine a threat that's reported as credible. And therefore,
There's no discovery really yet on policies of the department or anything like that.
no, there's not. And
Okay.
what we're arguing is that you don't need it because a failure to act cannot constitute recklessness under the circumstances. And I'd point out again, there was no order of protection because it was dismissed, and he was living in Clifton, Tennessee at the time this happened. And also, alternatively,
Wait a minute, what does Clifton, Tennessee have to do with it?
sorry, it's in the record, it's page 20. It's Clifton, Tennessee is in Wayne County, not Perry.
Right, but the guy who was making the calls was in Perry County.
Right, I guess what I'm saying is that it's only that failure to investigate and not anything Officer Portner may or may not have heard. And it's not in the complaint whether or not he's a Perry County deputy either. It just says Officer Daniel Portner. But also the GTLA doesn't waive immunity for recklessness. As you know, the GTLA is going to be strictly construed. And it says that the negligent conduct of officers or of employees can have waiver of immunity, not recklessness. So even if this court was to determine that she has sufficiently pled recklessness, the GTLA is not going to allow that under 292205.
That's only if we find that he was exercising a discretionary function.
No, Your Honor, under the GTLA, there has to be a waiver of immunity in order for the county to be liable. So outside of that, there is no, even if she adequately alleged recklessness, that does not waive immunity under 292205. That's to Perry County.
All right, thank you, Mr. Russell. We'll now hear from Ms. Thorne on rebuttal.
Thank you, Your Honor. Just to address very briefly a couple of things that were discussed as far as the special duty exception. The special duty exception, of course, contains 3 different subparts, and each one of those brings the duty down to the individual person. So it takes it out of the public at large and brings it down to the public official and the individual. Under subsection 1, that public official undertakes that duty affirmatively with that individual, and that individual relies upon it. Under number 2, the statute creates a cause of action for that individual to sue that public official. And in subsection 3, upon which we rely, the public official acts in a reckless manner and disregards a substantial risk as to another individual person. So I think there's some distinctions that can be made. I know that the Hurd case, the Wells case were mentioned, but when we're talking about serving an arrest warrant or failing to arrest someone on a probation violation, we don't know exactly who's going to be harmed by that. In this particular situation, the threats were distinct, they were specific, and they were made to a specific set of persons, 2 people, in fact, and those were the people for whom that Investigator Rawson was reckless. Specifically as to the Wells case, that relied on subsection 1 of the special duty doctrine, or the special duty exception, which is that the officer undertook the duty voluntarily. That's not the case here. In the Hurd case, again, which was talked about quite a lot, as stated in the reply brief, this court said specifically that the only allegation to support recklessness was that the sheriff spent too much time on his reelection campaign and not enough time on his statutory duties. So that is in stark contrast to what we have here, and that's the quote from the case. And then finally, just to address the last point that Mr. Russell made with respect to recklessness and how that interplays with the GTLA, I would just turn the court's attention to Brown versus Hamilton County. And in that particular case, and that was argued at the trial court level as well on this motion to dismiss. But in that case, the case was taken to trial. At the conclusion of the proof, the defense moved to dismiss based upon the exact same defenses that are presented here. 1, discretionary function, 2, public duty doctrine. And the trial court dismissed that case. On appeal, that was reversed. And this court said that at least one of the government acts was operational in nature, leading to the removal of the GTLA. Then turning to the public duty doctrine, it met the 3rd special duty exception, which was recklessness. So that's what we've alleged here. And that rendered the county liable under the GTLA. So Brown specifically addresses the interplay between those defenses.
All right, thank you, Ms. Thorne and Mr. Russell, for your arguments. You've given us a lot to think about. We'll take this matter under advisement. Ms. Lindsay.
This Honorable Court of Appeals is in recess until 2 p.m.
All right, and counsel, you are free to exit the meeting.
Thank you.
Thank you.